My presentation is on spoliation and social media journalism. I want to start with some points that are going to be made over the course of the presentation. I'll give you breaking news on Schrodinger's cat from Hackaday. I'll go over the Zurcher versus Stanford Daily case from 1978, the Supreme Court case, the Privacy Protection Act of 1980, and why I believe a particular clause in that act really gives us reason to pause as journalists if we plan on using Snapchat. Finally, I'll end with whether or not the reporter is a just person by using the ring of Gyges from Plato's Republic. So I want to go to the breaking news. Yale researchers have announced that they know the answer to Schrodinger's question about whether the cat in the box is alive or dead. At the time that Schrodinger posited this idea, it was to try and capture the indeterminacy at the heart of this question of qubits. The researchers believe that they now know one way or the other. They're able to predict using microwaves which way it will end. That was not the case back in 1978 when the Supreme Court heard a case that went back about a decade. In 1971, journalists were embedded with protesters during an anti-Vietnam protest on campus in one of the administrative buildings. Officers were harmed, and the paper chose to publish photos from that day 2 days later in the paper. The Santa Clara County District's Office was able to get a warrant. It was issued with just, probable, and reasonable cause of believing that material evidence would be located on the premises of the Daily. The photographic laboratories, filing cabinets, desks, waste paper baskets were searched. And then later that month, the Daily chose to sue not only the officers who executed the warrant, the chief of police, the district attorney, and the judge who issued the warrant. The Northern District of California Court heard the case and attempted to make a distinction between what the rights and responsibilities of a general citizen might be and what that of a reporter might be. And they said that the reporters should have been given the opportunity of answering a subpoena rather than having a warrant issued against them. The Supreme Court decided to reverse that Northern District of California decision because they felt that citizen as opposed to reporter is where the accent should be. Congress disagreed and went ahead and passed the Privacy Protection Act of 1980, which includes a particular clause that is built off of the reasoning of the Northern California District Court. That is that you should default to the subpoena unless there's reason to believe that the giving of notice pursuant to a subpoena would result in the destruction, alteration, or concealment of such materials. Well, when the Congressional Act was passed in 1980, we didn't have Snapchat. And what Snapchat does, what apps like Snapchat or Confide or any of the others, what they do is they blur that line around the question of the federal rules of civil procedure. Because what you are expected to provide is any electronically stored information. When apps are designed so that they embrace the principle of privacy by design, the front-end features, the back-end data, the retention policies governing those are such that Snapchat could not provide the evidence if they were served a warrant, nor could the person using the app, because within a few hours, maybe up to a month, the content of the messages disappears. So, Confide is an app that has been used recently by the governor of Missouri, by White House staffers, and so reporters might contend that they are only keeping up with the subjects of their inquiries, that they need to be as nimble and as crafty as the people who are attempting to hide information from them. The problem with that is that if we consider the Privacy Act of 1980, they would then be putting themselves in a position where they should expect warrants to be served, possibly electronic warrants, which means that it's not an officer showing up at your door, but it's material that you may be housing on a server that is subject to discovery, and you'd be better off not creating the presumption that you traffic in the destruction of property as a way of doing business. So social media falls within the scope of electronically stored information, but what is still indeterminate is how we will proceed in the future, knowing that that we have to define inaccessible ESI. That is because the undue burden or the cost of recovery would be such that, that it should not be made a part of any legal proceeding. That leads us to where courts have gone. They have examined the discoverability of transitory ephemeral data, and they have taken a look at the idea that inaccessible ESI may forever change how we approach this question. Others have argued that Snapchat is only mimicking what real-time phone or face-to-face communications did back in 1971. So we are left with the question of whether or not the reporter is the person who makes that decision, or if as a society we will make that decision together. The Ring of Gyges is where I'd like to end, where you have this idea of having great power and needing to have great self-discipline in order to execute that power justly, to use that power justly. I believe that social media apps like Snapchat and Confide put reporters in the position of deciding what to do with the ring. Thank you.